lady, my lords. Just before we rose, my Lord Reid was putting to me some questions about the commercial banking case. And I should have just made clear, I think, in response to those questions, that in that case, the request for a reference made no reference whatsoever to any client. So the defendant bank's knowledge that there was some client behind the request was purely inferential knowledge. It was not. It was nothing that was referred to. Issue 3, the purpose of the reference. The Court of Appeal seemed to have thought that the description of the purpose was not sufficient to found a duty of care, and in any event, the respondent seeks to uphold their decision on that basis. We can see the description of the purpose of in the request itself at core page 131. Where you have the request, and just you can see the words of the request are: we request your opinion as to the means and standing of Mr. Barakat, an address and an account number, and his/her trustworthiness to meet a financial commitment to the extent of 1.6 million at any one time. Please confirm in your reply the above account number is in fact a personal account. And we can also see that the nature of that was understood from the reference itself at page 133, where the bank writes, we confirm and certify that Mr. Barakat maintains account number 301 with us to our satisfaction. He's financially healthy, capable to meet his business commitments and all his obligations. Mr. Barakat is trustworthy up to the extent of 1.6 million sterling pounds in any 1 week. And we say, it's very simple, we say, my lady, that this was a general description of the purpose within Lord Oliver's formulation in Caparo, which told the bank that the reference was required by somebody who was contemplating accepting a financial commitment from Mr. Barakat up to the figure of 1.6 million. In other words, somebody was proposing to extend credit to him in some form up to that amount. And that description, it's sufficient to meet the Lord Oliver test, if I can call it that, because it limits the bank's potential liability to 1.6 million. It makes it quite clear that that's what it's for, which makes it a very different case to Caparo, where a shift to a different purpose made liability indeterminate. The other important point is that the description of what was required here was truthful. It was in no way misleading. I mean, that's exactly what was required. More detail could have been sought or given if the bank had been interested in it. But as the judge found at paragraph 49, which I showed my lady and my lords earlier, there was no basis in the evidence before him for treating the financing of trading in a casino as being of any different order to any other kind of trading or financial activity. And that, in my submission, was a matter of fact. It was a matter of fact for the judge to investigate, for the parties to investigate a trial, and for the judge to make a finding on as he did. So, my lady and my lords, for those reasons we submit that the purpose for which the reference was requested and given was described in admittedly general terms, but in sufficient terms. And if the bank had wanted to know more, it could have asked, but it was sufficient to found the duty of care that the judge found to exist. Those are the submissions that I'd like to make, unless there's any other point on which I can assist the court at the moment. If not, then for the reasons I've given, I would respectfully ask this court to allow my client's appeal and restore the order of the trial judge.
Thank you, Mr. Sarzido. I don't get the impression that there are any more questions to be fired at you, but thank you very much indeed. Mr. Hobson?
Lady, I don't. Thank you.
Mr. Chapman?
My lady, my lords, may I start by making 2 introductory points, and then I'll outline the roadmap for the submissions that I intend to make. The first introductory point is that the club accepts in paragraph 11 of its printed case on page 47 of the core bundle that in this case there is no evidence that the bank knew that the reference would be passed to or relied upon by a person other than Burlington. Nor is it suggested that the bank should reasonably have foreseen that the club would rely on the reference. That, in our respectful submission, is not just an unpromising beginning, it's fatal to the club's claim that the bank owed it a duty of care. The doctrine of the undisclosed principle cannot replace the need for the club to establish that it was reasonable for it to have relied on the representation, and that the bank should reasonably have foreseen that it would do so. See NRAM and Steele, which I'll come back to, tab 17, pages 806 to 808 of the bundle. The club cannot satisfy those conditions, and accordingly the Court of Appeal was correct to find the bank did not owe the club a duty of care. The second point, by way of introduction, is even if the club was right in contending that in principle a representor could, without more, owe a duty of care to an undisclosed principal in respect of a negligent misrepresentation made to the undisclosed principal's agent. On the facts of this case, no such duty of care would arise. The bank did not lead Burlington to believe that it was willing to treat a representation made to Burlington as being made to anyone on whose behalf Burlington was acting. The reference was sought on behalf of Burlington alone, and it was provided in strict confidence to Burlington alone. There is no room in those circumstances for the importation of the doctrine of the undisclosed principle. I'm going to divide up my submissions into 5 sections, all I hope reasonably short. The first will be 4 brief factual matters underlying the Court of Appeal's decision. Secondly, the principles applicable to the law of negligent misrepresentation. Thirdly, the basis for the doctrine of the undisclosed principle. Fourthly, reasons why the club's attempt to apply the doctrine of the undisclosed principle to the law of negligent misrepresentation should fail. And fifthly, alternatively, if the club is correct that the doctrine of the undisclosed principle may be applicable to the tort of negligent misrepresentation, why the club's claim would still fail on the facts. Can I start then with the 4 brief factual matters underlying the Court of Appeal's decision, which will require looking first of all again at the status inquiry request, which was signed by the customer, is in the core bundle at 131.
Sorry, what page again?
131, 131. And the points we make in relation to this are that, first of all, the document signed by the customer is on the headed paper of Burlington. One sees that. It's also headed private and confidential in the top left-hand corner. We, if you look under the heading status inquiry request, we request your opinion, that's Burlington Street Services Limited, as to the means and standing of Mr. Barakat and his details and what sort are then set out. And the consent that's been given by Mr. Barakat is that he hereby consents to the bank providing a reference on me to Burlington Street Services Limited. There's no blanket authority, which would be letter B, and it's signed by him and dated. So that's the first point, the contents of the status inquiry request. The second point is that the request for a reference was made by Burlington because that was the club's standard practice, designed to preserve confidentiality for customers preferring to keep their gaming activities private. That was a finding by the judge, paragraph 8 of his judgment, reiterated by the Court of Appeal in paragraph 1 of their judgment. It's a point that's also made by the judge in paragraph 49, where he refers to the concealment of the identity of the club. It's a key point underlying the Court of Appeal's decision in our submission. Third point is that NatWest faxed the status inquiry request that we've just been looking at to the bank for the attention of Ms. Giudetti. The facts cover sheet is at page 129 of the core bundle. You can see where it's faxed, and it says, it closes the letter, which is at page 130, and the letter says, we enclose a reference on behalf of Burlington Street Services Limited, who'd be glad of your opinion in relation to Mr. Barakat, on the extent of his trustworthiness, etc. And then please fax your reply directly to Burlington Street Service Limited, care of NatWest. And it attaches the request for reference, the status inquiry report, which is at page 131. So again, the reference is being sought by NatWest specifically for and on behalf of Burlington Street Services Limited. And that is the entity to whom the reference is provided. The fourth point, reference is at 133 of the core bundle, dated the 13th October 2010. It's addressed to the representee, Burlington Street Services Limited, care of NatWest Bank, as requested. It identifies Mr. Barakat and gives a view on his creditworthiness, and the reference is expressly given in strict confidential to Burlington. And with respect, we echo the observations of the Court of Appeal in paragraph 22 of their judgment, that the natural meaning of that expression is that it is not to be passed on to and still less relied upon by third parties in this context. And context is important here because the context is that the reference is being given to Burlington Street Services specifically.
Is that perhaps not deducing a bit too much from those words? I mean, up till that point, there's nothing to indicate that there was anything special about Burlington Street Services or any particular characteristic of theirs which was of the slightest interest to your clients. And it's entirely consistent with their name, even if it's open, that they were in fact asking on behalf of somebody else. They're a services company on the face of their name. Now, I agree, they might be offering dry cleaning, but one rather doubts it in Burlington Street, perhaps. Anyway.
And leaving aside that geographical observation, my lord, I think there is one important point. The consent to the reference being given at 131 by the customer is being given to provide it to Burlington Street Services Limited only.
Well, no, the word only doesn't apply, does it?
Well, it's
to Burlington Street Services Limited, and there's just no information why they wanted it. I mean, on the logic of your case, even if they were the services company for a group, and it makes no difference. That appears to be this situation, actually.
It doesn't. It's true. It is. It doesn't say only, but the next letter B refers to giving a blanket authority for the provision of references in more general terms, and that's not signed.
Sorry, where is that one?
So you're looking at 131, just underneath
Yeah.
letter A, your lordship was looking at.
Yeah.
There are two possibilities. The customer can either give a general
Yeah.
authority to provide references generally, or he can give, in this case, a specific authority to provide a reference to Burlington Street Services Limited. And what's being sought is his consent to the bank providing a reference to Burlington Street Services Limited. That's why I add the word only. That's by way of submission. But in my submission, it follows from the absence of the general authority being given under letter B.
Well, wait a minute. Yes. I see. You think B could be... Yes, it would have to be filled out with BNR, BNP Paribas, yes.
Yes.
Well, it's funny. It says Bank PLC. But, anyway, it's the same problem under A.
I think that's just a feature that we're dealing with an Italian bank here, and the form was obviously designed to be used for the more common occurrence where the bank will be English. But that's why I say only, and that's why in relation to confidential, I say it needs to be read in context. And the context includes the fact that the reference is sought for and on behalf of Burlington Street Services Limited, rather than in more general terms.
Well, I wonder whether B isn't actually, I mean, it may not matter a hoot, but B may not be intended to be filled out in circumstances where this document is addressed to, not to a bank, but to someone. Well, yes, I see. It confirms that the BNP holds a blanket authority. And who would it be addressed to then?
Well, that would be addressed to the bank. This is being provided by NatWest.
I would have thought then it might be, if B were filled out, it might be addressed to Burlington Street Services rather than to the bank. I confirm that BNP Bank holds a blanket authority. It seems to suggest that you're confirming to someone other than BNP that this bank holds a blanket authority to give references on your behalf.
Both of these declarations are being signed by Mr.
Absolutely.
Barakat.
Yeah.
So he is making one or the other statement. Either he is saying they're generally empowered to do
Right.
this, or I hereby empower them on this occasion.
Yeah, but in the case of B,
They're both addressed to the bank from whom the reference is being asked.
I hereby confirm that
Yeah.
BNP,
no, it would.
etc., holds a blanket authority for the provision of references.
Yes.
Specific or general, but in each case addressed to the bank.
Yes.
Yeah.
And in this case, referring to a specific addressee,
Yes. Precisely. Precisely, my lady.
which is your point.
Which is my point. Can I move to section 2, that's section 1, which is the relevant principles applicable to the law of negligent misrepresentation. I've tried to bear in mind the strictures of Lord Steyn in Williams and Natural Life, that the sole purpose of the citation of precedent is or ought to be the identification of a legal principle or rule which covers or may arguably cover the issue in the case to be decided.
Counsel of Perfection.
As I think probably all advocates say that before launching into their list of authorities, but I'm only going to refer to four cases. The first case is Headley-Burn itself, and I can take this a little bit more briskly because the court's already been shown some of the passages that I was going to refer to, and knows that in Headley-Burn, John Foster, QC counsel for the bank,
Sir John, yeah.
Sir John Foster, yes, of course, contended that on the evidence, the bank did not know that the National Provincial Bank required the information for the appellants or any other customer, and contended that, quote, an undisclosed principal is not a neighbour within the rule in Donoghue and Stevenson. And that's at 451 and 452 of the electronic bundle, if I've added 171 correctly.
Well, could you also give the law reports page, since I'm not watching it?
Yes, it's in the law reports page, it's 473 to 474. It's at the foot of 473 and the first line of 474. But in our submission, Headley-Burn was not treated by the majority of the House of Lords as a case concerning an undisclosed principle. Rather, it was treated as a case of a disclosed but unidentified principle. And the undisclosed principle argument advanced was clearly rejected by Lords Reid and Morris. It was probably left unresolved by Lord Hodgson and Lord Devlin, and only Lord Pearce, I'll come back to this, referred to the case as relating to an undisclosed principle, although he doesn't explain what he means by that phrase or refer to the evidential issue. It may be the better view that he was using that phrase in a non-technical sense and wasn't intending to determine the actual issue. But can I just make those points good? First of all, starting with the trial judge, Mr. Justice McNair, as he then was, didn't make a clear finding about the bank's knowledge as to who would rely on the reference. Parties agree in relation to that. But we say there is a clue in the way he frames the issue which he has to decide, which is then referred up. His judgment is in tab 8 of the authorities, and the passage is in the electronic bundle at page 416, which is 352 of the report.
What page for the report?
Page 352 of the report. And he deals there in the first full paragraph with, it says, the first question of law to be decided is as to the extent of the duty, if any, owed by the defendants to the plaintiffs in the circumstances set out above. Apart from authority, there will be much to be said for the view that a person who answers an inquiry as to the creditworthiness of another, knowing that the inquirer will probably act upon the answer, should be held to be under a duty to exercise reasonable care in giving the answer and to be answerable in damages if the answer proves to have been given negligently. And in our submission, Mr. Justice McNair, like Lord Reid, whose dicta you've already seen, was treating the case as one in which a negligent misrepresentation was made directly to the person seeking the information, opinion, or advice. The passage from Lord Reid that you already looked at is in page 460 of the electronic bundle, which is also page 482 of the report. And I'm not going to read that again, as you already looked at that this morning. So that's the position of Lord Reid. Lord Morris found at 471 to 472 of the electronic bundle that the bank must have known that the inquiry was being...
Page of the report?
I'm so sorry. That's at 493 to 494. The last line of 493, the bank must have known that the inquiry was being made by someone who was contemplating doing business with Easy Power Limited, and that their answer or the substance of it would in fact be passed on to such person. Lord Hodson understood the appellants to be contending for a duty of care to be imposed on the respondents when they gave a reference as to the creditworthiness of Easy Power Limited, knowing that it would or might be relied upon by the appellants or some other third party in like situation. That's his summary of the appellant's case, which appears in the printed report at page 505, page 483 of the electronic bundle, halfway down the page just below the first hole punch. It's not clear whether he proceeded on that factual basis, but he does go on to agree with Lord Morris at the end of his speech at page 514 of the printed report, which is E492. I agree with Lord Morris that if in a sphere where a person is so placed that others could reasonably rely upon his judgment or his skill, or upon his ability to make careful inquiry, such person takes it upon himself to give information or advice to, or allows his information or advice to be passed on to another person who, as he knows or should know, will place reliance upon it, then a duty of care will arise. So perhaps it's fair to say that Lord Hodson was prepared to treat the case as involving an unidentified rather than an undisclosed principle, even if he doesn't resolve the evidential issue. Lord Devlin appeared to be proceeding, if one looks at at page 530 of the electronic bundle, which is, 530 of the report, which is page 408 of the electronic bundle. 408 of the electronic bundle. Halfway.
No, afraid not.
Can't be.
Oh.
We've shot out of it.
508. There we are. Yes, that's my arithmetic, I'm afraid. He refers halfway down the page by the first hole punch to Mr. Gardner. Counsel for the appellant does not claim to succeed unless he can establish the reference was intended by the respondents to be communicated by the National Provincial Bank to some unnamed customer of theirs whose identity was immaterial to the respondents for the customer's use. All that was lacking, he says, was formal consideration. But it is the case that when he refers at the end of his speech to the rival contention that it was not to be inferred the respondents knew National Provincial Bank were asking for the reference for the use of the customer, which is just turning on, it's at page 511 of the electronic bundle, or page 533, this bundle. And that's where he refers to the respondent's contention and says that it's unnecessary for him to determine that because of the effect of the general disclaimer. And finally, Lord Pearce considered, again the court's already looked at this passage, that there was such a special relationship in the present case as to impose on the defendants a duty of care to the plaintiffs as the undisclosed principals for whom the National Provincial Bank was making the inquiry, and that's at page 517 of the electronic bundle, page 539 of the report. And in context, our submission is that it seems that Lord Pearce must be using undisclosed principal there as a synonym for unidentified principal, or perhaps to include both unidentified and undisclosed principal, because it's an odd expression to choose where there is plainly an evidential issue between the parties, and the decision doesn't depend upon the resolution of that issue because of the effect of the general disclaimer. So that's all I wanted to say about our submission, that Headley-Byrne was treated as a case of a disclosed but unidentified principal. The second case I wanted to refer to was Caparo, which is in tab 2 of the bundle. The first is the passage from Lord Bridge, which is in paragraphs, at pages 188 to 189 of the electronic bundle, and page 620, 621 of the case report. This is the passage where Lord Bridge observes that a salient feature of liability was that the representor knew that it was very likely that the representee would rely on the representation. And that proposition appears from the passage which starts at letter H on 620. And
So what's the critical, what is the critical test in your view? If it was probable that Burlington Street Services Limited were acting for somebody else, as was the case in Headley-Byrne with the bank, you'd lose, wouldn't you? Now, what if you just don't know, but there's a clear likelihood or a possibility, less than 50%, because you don't have any means of forming? Is that good enough?
No, that wouldn't be good enough. The relevant inquiries are the tests that are the two distinct inquiries that are indicated in Steele. Firstly, to establish that it was reasonable for the representee to have relied on the representation, so a question of reasonableness. And secondly, should the representor have reasonably foreseen that he would do so? And that's...
A reasonable foresight, does that connote probability, or is it sufficient that it's reasonably foreseeable that someone will be standing outside my garage if I drive out without looking? I mean, it's maybe improbable, but it's certainly reasonably foreseeable. Why isn't that sufficient in this context?
Well, in this context, reasonable foreseeable would, we say, drive you back to looking at the context in which the representation was sought.
But if the context is that it obviously didn't make any difference whatever to your client, who Burlington Street Services were or why they were asking for it, why in that particular context shouldn't it be possible for someone to step in? It is rather odd that in contract they could, and in tort they couldn't, even though it wouldn't have made any difference at all.
Well, we say it's starting from the wrong end of the telescope, because the inquiry that you need to make is whether it's reasonable for the representee to rely upon it, rather than looking at who else could have relied upon it
Isn't that
reasonably.
circular? Because if the representee can see that it doesn't make a blind bit of difference to the representor, then it would be reasonable for the representee to say, well, it doesn't make any difference to them whether they know who I am or why I want it. I can rely on it. The whole thing is a circle.
Well, that might be so, but that's not this case. In this case, it was important for the club that it maintained a distance between the seeker of the reference and itself.
Yes.
And it led that evidence. That was its positive case, that it put
The
itself...
explanation of why they did it in this way. Yeah.
Yes, exactly. And therefore, the oddity here is that having chosen to seek the reference in that way and keep themselves out of the spotlight so far as the reference was concerned, they're now seeking the assistance of the law and tort combined with a particular aspect of the law of contract to fill that gap in.
I mean, there are perhaps two different things. I mean, there has to be a reasonable foreseeability of reliance, which is the point emphasised in NRAM and Steele. But Lord Reid begins his judgment in Hedley Byrne by explaining why this isn't Donoghue and Stevenson, that acts are different, that words are different from acts. And for there to be liability for words, there has to be some relationship between the speaker of the words or writer and the person who acts on them, which is greater than merely reasonable foreseeability.
Yes, and that's led to the analysis of Hedley Byrne as being a case of assumption of responsibility, and whilst that's the high level label that one looks at, one then looks at the lower level.
Yeah, and Lord Bridge, I mean, you're going to go on to this, no doubt, between E and F, deals with this in terms, he uses the word proximity, but it's the same idea that there has to be some particular form of relationship which is based on the knowledge.
Yes, exactly.
Of the identity of the person who's going to whom you are assuming a responsibility.
Yes,
The essential points, surely, are that the analogy with contract is that this is a relationship which is consensual and mutual. It's those two factors, isn't it? And it's not just that the consent is to enter into a relationship with a particular person. It's the mutuality of it which indicates that.
Yes, that's right. It's difficult to find that mutuality if the representor cannot reasonably foresee the identity, or doesn't know the identity of the representee who is going to rely upon the representation, either individually or inferentially as a member of an ascertainable class. So that is, so what we get from Law, Bridge and Caparo is the focus. I just go back to focus on the representor knowing it was very likely the representee would rely on the representation. Having referred to Ultramaris and Touche, he then says it was necessary to prove as an essential ingredient of the proximity between the plaintiff and the defendant that the defendant knew that his statement would be communicated to the plaintiff either as an individual or as a member of an identifiable class, specifically in connection with a particular transaction or transactions of a particular kind, and the plaintiff would be very likely to rely on it for the purpose of deciding whether or not to enter upon that transaction or upon a transaction of that kind. And that's connected with the passage from Lord Oliver that you've already looked at this morning, which is in page 216 of the electronic bundle. It's at page 638 of the report. And I think this has already been read. It starts at the letter C, what could be deduced from the Hedley Byrne case. Is that the necessary relationship between the maker of a statement or giver of advice and the recipient may typically be held to exist where the advice is required for a purpose, whether particularly specified or generally made known. 2, the advisor knows, either actually or inferentially, that his advice will be communicated to the advisee, either civically or as a member of an ascertainable class, in order that it should be used by the advisee for that purpose. And 3, it's known either actually or inferentially that the advice so communicated is likely to be acted upon by the advisee for that purpose without independent inquiry. And that's the way in which Headley-Byrne is understood. It's understood and explained in Caparo. One can then look at Customs and Excise, just the one paragraph in Customs and Excise, to see what Lord Hoffman says in relation to it in the well-known paragraph 35. It's at tab 6. It's an electronic bundle 320, the electronic bundle, and in the report it's at page 198 to 199. And could I ask the court it's a familiar paragraph, could I ask the court to read paragraph 35, please, and then I'll just highlight the passage on which we particularly rely.
I think you like the sentence with all the bracketed bits in it, don't you?
I rather do. I may have given that away in our printed case, but that rather seems to us to be key. Critical to decide whether the defendant, rather than someone else, assume responsibility for the accurate information to the claimant rather than to someone else, or for its use by the claimant for one purpose rather than another. It goes on, the purpose of the inquiry is to establish whether there was, in relation to the loss in question, the necessary relationship or proximity. And these are the high-level labels that are sometimes used. But that's the specific inquiry which needs to be carried out. It's rather difficult to square that highlighted sentence with all the brackets in with the idea that there could be liability to an undisclosed principal without more.
Well, it depends, doesn't it, under the next sentence, on what could reasonably be inferred from his conduct against the background of all the circumstances of the case.
Well, we would. That's plainly part of it. That's why I use the phrase "without more" in relation to an undisclosed principal. And it's possible for there to be liability if you make if A makes a statement to B. It's possible for there to be liability to C, who's the undisclosed principal of B, but not just because C is the undisclosed principal.
No, I mean, if somebody had written less saying that making any inquiry, it may or may not be according to the particular circumstances that we're acting on our own behalf or on behalf of somebody else.
Then
you wouldn't have a clue whether they were in any particular case. It would be undisclosed, but it would be a possibility.
It will be a possibility.
Disclosed possibility, and you would have taken the risk.
Quite. Yeah. Quite.
There's not a question really of probability. It's a question of what you reasonably accepted by the representation or and read in the surrounding circumstances.
Yes, I think it's a fair way of putting it. That's the final case I'm going to refer to is in the NRAM and Steele case, which is in tab 17. Page 801 of the electronic reports.
I'm so sorry, I missed that number.
801 of the
Thank you.
electronic bundle. Tab 17.
Yeah.
The hard bundle. It's the judgment of Lord Wilson, with whom two members of this court expressly agreed. And the court reviewed the post-Headley-Byrne landscape of authorities and refocused attention on the need for a representee to establish that it was reasonable for him to have relied on the representation and that the representor should reasonably have foreseen that he would do so. And The court emphasises that those two inquiries may be distinct, but it's critical they're carried out because the results will inform the question whether or not there has been an assumption of responsibility, and therefore whether a duty of care is owed. And we rely on the discussion in Steele at paragraphs 19 to 24. I hesitate to ask the court to take time to read them, but it's, as it's so recent. But.
Well, not everybody was in the case. Where did you want us to get to?
To the end of 24.
I think you may go on.
Grateful. The appellants assert, that passage is authority for the propositions that where A provides information to B and it's used by C, then there can only be liability where it was reasonable for C to have relied on what A said, and A should reasonably have foreseen that C would rely on what A said. I'm going to shorthand refer to those as the Steele questions. They're not new, but they're distilled from the authorities and really intended, I think, in my submission, to be lower level questions below the concept of assumption of responsibility. Now, the appellants assert that the governing principle of Headley-Byrne and the underlying principle of Headley-Byrne liability is equivalence to contract. In our submission, that's not right. The effect of a duty of care arising because there's been an assumption of liability might be, in certain respects, equivalent to a duty of care arising under a contract. And as a matter of fact, where there are circumstances which are equivalent to contract, a duty of care in tort may well exist. But that doesn't tell you anything about whether or not a Headley-Byrne duty of care exists. For that, you must ask the lower level questions, such as the ones identified in Steele. And our respectful submission, equivalent contract is, it's really of value only as a label rather than an indicator as to when one is going to find a duty of care arising in situations such as under consideration in this case. That's what I wanted to say about Section 2, the law in relation to negligent misrepresentation. Section 3, so I wanted to make 2 points on the basis for the doctrine of the undisclosed principle. The first point is, as is accepted, that the development of this branch of the law is now justified on grounds of commercial convenience only. It's an anomaly developed to deal with a practical problem, and notwithstanding that it runs counter to privity, it's been said on the highest authority that it's too late for it to be changed at this stage in the law of contract. In our submission, that is not a sound basis to rely upon where the court is being asked to undertake an incremental expansion of the law of negligent misstatement. Second point is that in the context of the undisclosed principle doctrine in the law of contract, as the court has looked at this morning in the Sue and Eastern Insurance case, the terms of the contract may expressly or by implication exclude the principal's right to sue and his liability to be sued. The contract itself or the circumstances surrounding the contract may show that the agent is the true and only principal. And this is our alternative submission. If contrary to the bank's primary case, the undisclosed principle doctrine is somehow applicable to the law of negligent misrepresentation, then the circumstances surrounding the giving of the reference here, because obviously there's no underlying contract, but surrounding the giving of the reference, show that Burlington was the true and only principal. The court could probably anticipate why I'm going to say that is, and that's very briefly what we'll be saying in Section 5. Section 4 is the reasons why the club's attempt to apply the doctrine of the undisclosed principle to the law of negligent misrepresentation should fail. And I start off by making 2 points. The club accepts in paragraph 10 of its written case, as it must, that where A provides information to B, which is passed to and relied on by C, the general position is A will only owe a duty to C if A knows its advice is likely to be communicated to C either specifically or as a member of an ascertainable class. That omits reference to the other condition set out by Lord Oliver and Caparo, namely that it has to be known to A, either actually or inferentially, that the advice so communicated is likely to be acted upon by the advisee for the known purpose without independent inquiry. And here we say the bank did not know that the information it provided was likely to be communicated to the club, that the club was likely to act on the information provided, and that the purpose for which the club was likely to act on the information was to allow a check cashing facility for a bank customer for gambling at a casino. And we say that special purpose is not something that appears from the general request for a reference. Second point is the club asserts that the Court of Appeal's reasoning, this is paragraph 14 of its case, written case, that where an advisee is identified by name, as Burlington was, that will always exclude a special relationship from arising between the advisor and anyone other than the identified advisee. With respect, paragraph 22 of the Court of Appeal's judgment, which is at page 99 of the core bundle, is a little more nuanced than that. At paragraph 22, if one goes 2/3 of the way down, one banker seeking a reference from another may well be understood to be doing so on behalf of a customer, even if, unlike Hedley Burns' banker, he does not make that clear at the time. But if the requesting banker actually names the person on whose behalf he is acting, there will usually be no reason for the banker providing the reference to think that it will be relied on by anyone else. And then that's particularly so where the reference is given in strict confidential and the natural meaning of strict confidential. And with respect, the Court of Appeal is right there. There usually will be no reason for the banker to provide the reference to think that the reference is going to be used by anyone else. It's possible, of course, to conceive of factual situations in which other knowledge is available to the bank, but that's not this case. The club then gives it its written case 6 reasons why an assumption of responsibility ought in principle to be capable of extending to an undisclosed principle which relies on a statement addressed to its agent. And obviously we deal with those in our written case, but can I just make some comments on each of those 6 headings? The first point is paragraph 17 of the club's case, it said if there had been a contract between Burlington and the bank to provide the reference, then the club would have been entitled to intervene and enforce it as an undisclosed principle. Well, we disagree with that proposition on its facts because of the circumstances in which the reference was provided, but we also say, as a matter of principle, it's the wrong place to start. It's no part of the law of negligent misrepresentation to ask what the correct legal analysis would have been if there had been a contract. If there had been a contract, we wouldn't be asking whether or not there's been an assumption of responsibility. And the club is positing equivalent contract as a replacement for asking the higher level question, has there been an assumption of responsibility, and the lower level questions applicable to a bank reference case such as this, the Steele questions which I've already been into. The appendix to our written case makes the point that the authorities relied on by the club as mentioning the phrase equivalent contract also refer to the necessity of the representor knowing that its statement will be relied upon as being an essential feature of the assumption of responsibility test. But in any event, we say the phrase equivalent to contract is used to indicate the kind of situations where a duty of care is likely to arise. It's not intended to import the quasi-contractual analysis to the law of tort. If Lord Devlin had considered it was sufficient for the claimant to sue as an undisclosed principle, he would no doubt have said so when he considered the case that was being advanced on the facts. But in fact, as we've seen, he summarises the appellant's case on the basis that it only claims to succeed if it can establish the reference was intended by the respondents to be communicated by the National Provincial Bank to some unnamed customer of theirs. All that was lacking was consideration. And we say that's inconsistent with the appellant's attempt to interpret Hedley Byrne as supporting, even by analogy, an analysis incorporating potential liability towards a true undisclosed principle. The second point asserted in paragraph 29 of the appellant's written case is that the recognition of a duty of care towards an undisclosed principle is a corollary of the established principle that an assumption of responsibility may arise through an agent. And we disagree with that proposition. The fact that C may be an undisclosed principle of B does not tell you, without more, whether or not A, the representor, owed a duty of care to C. You have to go back to asking the Steele questions. Was it reasonable for C to have relied on what A said? And should A reasonably have foreseen that C would rely on what A said? It's also possible to ask whether incrementally this is the kind of case where liability for negligent representation should be extended. But that would mean extending the law to include cases where A could not have foreseen that C, either individually or as a member of an ascertainable class, would rely on A's statement. And the justification for that would have to be that the court deemed A to have that knowledge because of the law of undisclosed principles, which we say would fly in the face of the development and explanations of the assumption of responsibility principle since Hedley Byrne. In that context, reliance on the Cramasso case is misplaced. In Cramasso, which is at tab 5, looked at this morning, what was important was that the accuracy of the representation continued to be asserted by the representor implicitly after the identity of the prospective contracting party had changed. And one sees that from just from the head note at tab 5, page 280 to 281 of the electronic bundle. Starting from the left.
not an agency situation at all. It's,
No, it's not. It's not. It's a by the time it reached this court, it was analysed and correctly analysed as a continuing representation case, but it didn't turn not on any inferential knowledge of the agent being attributed to the principal. The third point made by the appellants in 42 to 43 of their written case, dealt with in 25 to 27 of our written case, is that there would be no increase in the extent of the defendant's liability. The argument is that because only the club relied on the reference, the potential liability of the bank was not enlarged. But with respect, that's not an answer to the point of principle, LE. If the club is right, then when the bank gave the reference addressed to Burlington, it was also giving the reference to, and owed a duty of care to, any other person, individual or company, for whom Burlington was acting as an agent. Whether it was part of the group of companies in the Burlington group, or whether it was some other person, anywhere in the world. Even if the bank did not, particularly if the bank didn't know the other company existed, or that it was going to rely on the reference. And we've made the point in footnote 9 to our written case that the parent company, the second appellant, appears from its accounts to have 18 subsidiaries. It's page 78 of the court bundle, including Burlington and the club. And therefore, we say, contrary to the club's assertion, the potential liability of the bank was enlarged, and that's only looking at subsidiaries within the appellant's group. And the suggestion at note 40 in Core Bundle 56, and it's repeated this morning, that the bank's liability will be limited up to £1.6 million a week, doesn't answer the objection to the number of parties to whom the bank was potentially liable. In any event, the reference here that Mr. Barakat was trustworthy up to £1.6 million in any 1 week could in principle, in theory, extend to a multiple of 1.6 million, depending on the number of weeks involved. But I think my primary point would be that there's just no limitation if one relies on actual authority, an internal arrangement as between Burlington and a third party. The fourth point is the analogy with Headley-Burn itself. And I've dealt with this to some extent already, looking at what Headley-Burn, the true principle to be derived from Headley-Burn. It's also dealt with in our written case at 28 to 32. In the grounds of appeal, it was asserted, page 155 of the core bundle, that Headley-Burn concerned a situation involving an undisclosed principle. And the Court of Appeal was wrong when it said there was no authority for the proposition that the club should be able to sue the bank as an undisclosed principle. Case is not put like that now. It's accepted. It's accepted that Headley-Burn was not or cannot properly be treated as an undisclosed principle case, notwithstanding some of the submissions that were made on behalf of the bank. And as I said, our submission is that it's properly to be regarded as a case where the principle was unidentified rather than undisclosed. In our case, in this case, the reference was sought by NatWest, passing on the request for a reference to the bank on behalf of what was, on the face of the request, a single disclosed and identified party, Burlington, with no hint given of the existence of any other person to whom or to which the reference might have been passed. The fifth point, this heading, is the objective nature of the assumption of responsibility test. I've dealt with this in our written case at 33 to 39. It's common ground that the concept of an assumption of responsibility includes an objective element, and that's to determine whether inferentially, as Lord Oliver described it in Caparo, the advisor knows, firstly, the purpose for which the advice is wanted, and secondly, that his advice will be communicated to the advisee, specifically or as a member of an ascertainable class, and thirdly, that the advice so communicated is likely to be acted upon by the advisee for that purpose without independent inquiry. Now, the fact that that's an objective and part of the test does not mean that the law of tort and the law of contract are the same. It's a different tests here. By undertaking an objective inquiry here, again, it cannot objectively be said the bank should have known any of those matters. The relationship between Burlington and the club was deliberately kept from the bank as a matter of standard practice, and applying an objective test, the bank didn't know, 1, the purpose for which the club wanted the advice, 2, that the bank's advice would be communicated to the club, and or 3, that the advice so communicated was likely to be acted upon by the club for that purpose without independent inquiry. The 6th point is that there is no policy reason, it's said, why liability should be narrower in tort than in contract. And again, it's the wrong question. The proposed change to the law sought by the club would not, in our respectful submission, be an incremental expansion of the law of misrepresentation, because it would impose liability just because there was an undisclosed principle, even where it was unreasonable for C to have relied on what A said, and A could not reasonably have foreseen that C would rely on what A said. And it would be inconsistent, we say, with the development of the law of negligent misstatement since Headley-Byrne, in which the answers to those questions, as we see from Steele, lies at the heart of liability for negligent misrepresentation. And in view of the analysis in Steele, there is, we would say, no room for the extension which is sought on behalf of the appellants. That brings me to my 5th and final heading. If the club is correct that the doctrine of the undisclosed principle may be applicable to the tort of negligent misrepresentation, why the club's claim would still fail on the facts, which is our case at 42 to 54, and I can summarise this extremely briefly. The first point, as the court knows, is that we say in the status inquiry request the customer consented to the bank providing a reference on him to Burlington, not to the club. Second point is that the status inquiry request to the bank was sent on behalf of Burlington, not on behalf of the club, and asked for the reply to be sent to Burlington, care of NatWest. And the third point is that the reference was sent to Burlington and given in strict confidence. I've made my points in relation to that. It's consistent with Burlington being the only person entitled to rely on it in the context of these facts. There is nothing in that material to suggest the bank was willing to treat a representation made to Burlington as being made to anyone on whose behalf Burlington was acting. Finally, there was no assumption of responsibility by the bank for the use of the reference by anyone for the purpose of deciding whether or not to trust Mr. Barakat in his gambling activities. That was not a purpose of which the bank was aware. Accordingly, it could not have been a purpose for which the bank provided the information to Burlington about Mr. Barakat.
That's a bit rich, isn't it? You didn't bother to ask. And what do you think it was for? It could have been for anything under the sun. To suggest that a bank which is willing to give an open reference is not responsible for particular uses, it seems to me, as I say, a bit rich.
Well, my lord, it's a reference that's given to Burlington. If one could.
You're saying that if Burlington had been running a gambling arcade, this would have been effectively, or any point, because the representation would have been made to Burlington, and you could have come along and said, sorry, we displayed not and had not the slightest interest in why this was going to be needed or why it was being relied on, and yet, since you failed to volunteer that, we're not liable.
Yeah, my lord, yes, we would have said that. We're not in that position. We would have said that because the general...
I know we're considering an alternative argument you're putting forward, and so I must test it by reference to an actual situation.
Yes, we would say in those circumstances that the general reference does not include the giving of a check cash facility to a
All right,
gambler
what
in a
things would you
casino.
have been liable for? I mean, if this had been an extension of credit for the supply of goods, would you have been liable?
Yes, we would be liable to the extent of a normal commercial transaction.
I see. That's the point, is it? That gambling, I mean, I can understand that. Gambling is pretty risky business, and it's outside the normal range of the matters for which references are asked.
Yes, that's what we would say. Yes, it's the same reason. It's the reverse of the reason why the club wishes to keep confidential or keep out of sight the fact that it's seeking a reference for the individual in respect of his gambling activities. And it's possible.
So, I mean, because a moment ago you were advancing the proposition that the purpose had to be disclosed, and you were reciting something that had been said in probably Capara.
Capara, yes.
But again, I mean, the risk is that one's taking things out of context, because accounts, as we know from Capara, are prepared for the use of the shareholders in general meeting, specifically not in the different capacity as investors of who might buy further shares. So that's a completely different context. I think it's difficult to advance as a general proposition that a reference is only valid if it's given for a specific purpose, if the bank doesn't ask what the purpose is. But I think, as I understand it, you were prepared to refine your submission so that it is that this reference would cover, even without disclosure of any particular purpose, normal business transactions, but gambling is not such.
Yes, that would be my submission, yes. My lady, my lords, ahead of scheduled time, unless there are any further questions from the court, those are my submissions of the bank.
You are indeed well ahead of scheduled time, Mr. Chapman. But I don't think there are any further questions. Thank you very much indeed.
I'm grateful.
Mr. de Maistre?
My lady, my lords, a few points in reply. My learned friend sought to characterise our case as being seeking an incremental extension, and indeed at one point says seeking a change in the law. I should just make clear that, of course, that's not the way I put my case. What I say is we are within the existing category of a relationship equivalent to contract, and what I'm asking this court to do is to say that the law is such that means what it says. That's all. So it's certainly not a change in the law, and nor am I seeking some new category in the law of negligence. I'm actually asking this court to interpret the way I say should rightly be interpreted, the existing category. It's notable, my lady, that there has still been no attempt to deal with the two paradoxes to which I drew attention in the event that the respondent's case is right. My learned friend did go to Cremasso, but didn't deal with the point I was actually making about it. I wasn't making the point that Cremasso itself was about an undisclosed agent. I was making the point that Cremasso showed that the liability for contractual misrepresentation is itself a form of Hedley-Byrne liability, and that there was therefore a paradox, if my learned friend's case is right, that there could be a contract made by an undisclosed principal. That's clear law and not disputed. And in that situation, that undisclosed principal would not be able to rely on a pre-contractual representation, if my learned friend is right. And nor did he deal with the paradox that I put forward, that if he's right, contributory fault would not be available to a defendant in a case of negligent misrepresentation, where
Not be able to rely on a tortious misrepresentation. Not be able to rely on.
Well, my point, my lord, was that what Cremasso makes clear
is an undisclosed principal would not be able, in the Cremasso type situation, to rely on
a misrepresentation which led him to enter into the contract.
Right. Yeah.
And so that would be to the detriment of the undisclosed principal. But the other paradox I drew attention to was the other way round, that that contributory fault would not be available against an undisclosed principal if my learned friend is right. And he made no. I simply draw attention to the fact that he, neither in his written case nor in his oral submissions, did he have any answer to those difficulties that would arise if he were right. The point was made that some reliance was placed on the consent given by Mr. Barakat. Can I just take you back to that, at core page 131? The consent is simply Mr. Barakat saying to the bank that he consents to them providing the reference to Burlington, which otherwise they might see as a breach of their duty of confidentiality. He's either going to confirm that he's already given consent in some general blanket form, or in practice in this case, that he does consent. That doesn't tell you anything about whether Burlington may be receiving it for his own account or his agent for another. I mean, of course, Mr. Barakat knows full well what the reference is wanted for. There's no suggestion in this case that it was concealed from Mr. Barakat. So he obviously didn't think his consent was inconsistent with the document being passed to the club. So what I say is that consent part of the form is entirely neutral. It doesn't tell the bank anything about whether Burlington might or might not be acting for somebody else. If they are acting for somebody else, Mr. Barakat is presumably aware of that, but that's all it tells you. Obviously, on some other facts, if Mr. Barakat had somehow been tricked into signing this without knowing that Burlington was the agent for somebody else, that could give rise to all kinds of different problems. But that's not our case. In a standard case, it's entirely neutral. My learned friend took up a suggestion, I think, from the bench that mutuality was missing from the situation in this case. Well, my lady, to some extent, of course, the essence of negligent misstatement is that mutuality is missing. That what's missing is both privity and consideration. That's what's missing as against contract, hence no mutuality. There is an aspect, though, which is close to mutuality, and indeed the word is used at one point in Headley-Burn, which is found in the idea that the representor is acting for some business reason of their own. They're not just acting out of altruism or some social reason. And there's two references to that in Headley-Burn, which are probably worth looking at on this specific point of mutuality. One is in Lord Devlin's speech, Headley-Burn at tab 10, page 529 of the report, page 507 electronic.
Sorry, can I just, before we look at it and before I forget the point, can I just ask you this? Cremasso was a Scottish appeal. In England, would the position not be governed by the Misrepresentation Act of 1967 if one party to a contract had been induced to enter into it by a misrepresentation made by the other?
Your Lordship may be right, and I apologise if I've stated something wrong in the law in that respect. I can't, on my feet, recall whether there is clear authority on whether contributory fault is available in that respect. But
I was also thinking about the position of the undisclosed principal.
Yes, well, my Lord, your Lordship may be right, and there may be a point in that sense that I haven't thought through. But my submission is that the underlying common law ought to be developing in a coherent way that would work even if the Misrepresentation Act hadn't been passed.
I understand. Thank you.
I think the Misrepresentation Act is just is another layer, isn't it? Really, it's not completely doesn't completely subsume tortious duty of care or the possibility.
Yeah. Well, my Lord, yes, I certainly would say that. Yes, yes, I do. So I was going.
It may not be may be situations where it doesn't go. May there be situations where it doesn't go so far? It probably does go further in some respects.
Well, in some respects, I'm sure it goes further.
It covers innocent.
Yes.
Well, it altered the remedies for innocent misrepresentation.
Yes.
Yeah.
And provided for damages from it.
Yes. Yeah.
So I'm sorry for the fact that I haven't actually incorporated that into my thoughts, but I do say that my submission is
It only just occurred to me as well.
Nevertheless, one would hope the common law would make sense without a sticking plaster of the Misrepresentation Act. And my submission is that it only does so if I'm right.
But the common law would make sense if the fact that the representor and the person to whom the representation was communicated then came into a direct contractual relationship with each other would or might supply the necessary proximity, might it not? I mean, that doesn't arise in this case.
My Lord, I see that, but there is the usual principle with pre-contractual representations is they have to be made before the contract. There's certainly authority in lower courts than this.
But what creates the compulsion of the law to give a remedy is that it induces the contract.
Yes, that's the reliance. That's right.
Yes, but it's a special kind of reliance. It actually doesn't. It's not just reliance in some dealing with a third party, as here. It's an inducement to enter into a contract with the person who makes the representation.
But the point about the undisclosed principal is that they enter into a contract without the other party ever knowing that that person is the one that they've entered a contract with. So that's so in the contract, the insurance contract in Xuyin Quan, for example, the principal was not named. The insurer never knew the name of the principal until they made a claim later, and that is the undisclosed principal doctrine. So in that situation, if, say, the insurer had made a misrepresentation inducing the contract, if my learned friend is right, then the employer would not have been able to obtain any relief for that misrepresentation, even though they've been induced to enter a contract by it. And my submission is that can't be right. And so there must be at least some cases in which an undisclosed principal can sue in tort. And if there are at least some cases, then I'm right on the law, and then we just get to whether the judge should be overturned on the facts.
Isn't there a difficulty with your attempt to introduce a principle of undisclosed principle into this area of the law that undisclosed principle, as was pointed out, is a doctrine which operates irrespective, regardless of foresight. You can have an undisclosed principle intervene in an ordinary commercial contract, even though you have no inkling that you may be contracting with anyone other than the person you're standing face to face with. That's an ordinary risk. Whereas in the context of negligent misstatement, the law has been focused around foresight, around what is reasonably foreseen and what is reasonably undertaken.
The undisclosed principle can certainly operate without actual subjective foresight, but what it amounts to is it's bringing together the fact that the law takes it as being the case, that it is normal and acceptable in commercial dealings, at least in most commercial dealings, for people to contract for a principal without necessarily volunteering that at the outset, or indeed at any stage, even when the contract is made. And so because of that, the law is willing to infer that the other contracting party does take that risk if he doesn't take steps to find out. So there's no clear, bright line about what is or isn't foreseen or known by the other party. The question is a question of inference and an objective assessment of what the other party is taken to know, to reasonably foresee, or to take the risk of. And the effect of the doctrine in contract law is the other party is taken to know or foresee or take the risk that there is somebody behind the person they're dealing with in general circumstances. Of course, there are factual circumstances where that won't be the case. And my submission is that is a perfectly appropriate approach to take forward into the law of negligent misstatement, which is said to be based on the situation equivalent to contract. It's exactly the same analytical approach. What's really different, what it narrows down to really, is a bit of a difference of where one starts, what the presumption is. And my learned friend essentially invites the court and the courts generally in this to start with a strong presumption that there's nobody lying behind the person you're dealing with unless they tell you that there is. And if you start there, then the general position would presumably be that you wouldn't have undisclosed principal liability. Whereas I say that the way the court should start is from exactly the same position as it started from in contract. You don't expect this kind of liability in tort to be narrower than contract. It's obviously wider in some respects, and the particular respect in which it's wider is the lack of privity and consideration. And in those circumstances, it's right to start with a similar approach to the approach that the court takes to the same question when it arises in contract. And on that basis, there can at least sometimes be an undisclosed principle, and it comes down to the facts and to the judge's assessment of whether this is a fit case for that to be the position on all the facts.
So what is the assessment of?
The assessment is of whether in all in all the circumstances.
And so your case is that undisclosed principle is always foreseeable. So what more is there to assess?
No, my lord, my case isn't quite that it's always foreseeable. My case is that the test is as in contract, that there may be circumstances that negative that as a possibility. There are some kinds of contract.
So that's the only assessment as to whether the circumstances actually negative the
yes, including
prima facie position. So it's just the same as contract.
Yes, the same as contract, including, of course, anything said or done by the representor, which might include saying something that makes it clear that it matters to them who the representee is. So yes, I say it should be the same inquiry as in contract. I got slightly diverted from just showing my lady and my lords the references to mutuality in Byrne. Can I just do that? Which is
Well, you showed us the one on
so
electronic 507.
I think I showed you the one at 529 of the report, 507 electronic, the end of the top paragraph there.
Yes.
The fact that the advisor is probably being done because their is giving a reference because their customers want them to. And the other reference is in Lord Morris at 503 of the report, 481 electronic.
Sorry, 5 each?
It's 503 of the report, 481, 81 electronic, where about halfway down the page, on the right-hand side of that paragraph, the bank need not have answered the inquiry from National Provincial Bank. It appears, however, that it's a matter of banking convenience or courtesy, and presumably of mutual business advantage, that inquiries as between banks will be answered. So there's one reference there to the word mutual. But as I say, in general, of course, there's no direct mutuality, and that's exactly why the law of tort, as Lord Steyn put it, fills the gap, because you don't have privity. The only kind of mutuality you have is that these are situations in which the representor is usually acting for some business reason. They're not just acting casually.
Well, it's mutual in the sense that it's consensual on one side and involves known reliance on the other.
My lord, yes, but I say that mutuality it doesn't need to go any further than the same mutuality that justifies a finding of a contract. But there is some mutuality. As I said, I think in answer to my lord's first question to me this morning, that it's not a case that undisclosed principle opens up the whole world with no mutuality. It is limited to those persons for whom the representee was actually acting. My lady, my lords, my learned friend submitted that the bank's liability was enlarged, or would be enlarged, by my argument, by the possibility of there being more than one principal. In my submission, he didn't grapple with what I said in answer to questions from the court, namely that for there to be reasonable reliance on a reference limited to a certain figure, the only way that could work is if the parties got together to ensure that they acted within the reference, in which case they would be acting as a single party. So perhaps in a group situation, you have a Treasury Department that somehow is involved in this area. So they effectively act as one person for the purpose of relying on the reference. So it does not expand the representor's liability at all, that in theory you could have a situation with more than one undisclosed principal. If you had a situation that goes beyond that, then the reliance does become unreasonable, and I accept in that situation, reasonable reliance becomes would then become the key test of what was going on. Then I just want to deal with what at least hit me as a new argument or a new way of putting it, namely that gambling was not merely not specifically disclosed, but was so unusual that it needed to be disclosed. And, my lady, it's a bit late to take that point. That's a matter of fact, which was the subject of a finding by the judge in paragraph 49, as I've showed you, namely that there was nothing unusual about it. The bank called witnesses who could have said something about it if they wanted to, but they didn't. And there's not even a finding of the Court of Appeal on this point to assist my learned friend. The Court of Appeal do say that the purpose wasn't fully disclosed, but they don't say that was because they think that gambling is so unusual that it makes a difference to whether a bank would give a credit reference. So that point is one which would require factual material, which is not before this court. My lady, my lords, are there any other points on which I might be able to assist, or at least to try to?
I don't think so.
Thank you very much.
Thank you very much indeed, Mr. Salzito. I'm grateful to everybody for their very helpful representations in this case. I use that word deliberately. We shall go away and work out what they've induced. Let you know in the usual way. Court is now adjourned.